With these three only you can get a patent. So what is new? A new product or process. What is this new? New, or sometimes we call novelty, means not published before the date of that patent application. Say today among you anyone files a patent application either online or offline to the patent office today on 4th May 2023. So till yesterday, means 3rd May 2023, whatever there in the public domain, it is all prior art or the state of the art. So it's all public domain. So for your product or process, we search in that public domain. If anything is there, your invention is not new. If nothing is there in the prior art or the state of the art, it is new. So that's how patent office we evaluate the novelty of a product or process which you are going to patent it. Inventive step means it is the obviousness also we call it as. So it is a feature of technical advancement over the existing knowledge. Or economic significance, it gives an immense economic significance to the companies or individuals or society, or it can be a both technical advancement as well as economic significance. But these two, whatever that is, it should not be obvious to a person skilled in the art. It is not obvious means you can say it is inventive, involve inventive step. Simple example, morning I was showing paper clip, and in comparison to pins, it is having an advantage, technical advancement over the existing products or existing knowledge. So when pins are destroying the papers, this is technically advanced, they are not destroying the papers. So like that, it is not obvious to a person skilled in the art. That is what we say it is a inventive step. And capable of industrial application means it is being made or used in any type of industry, whether it is a pharma industry or agriculture industry or FMCG, or it can be electronics, electrical, mechanical, any type of industries. There should be some advantage or utility for that product or process. So if that is there, then it is capable of industrial application. So when you are patenting in India, you should also see that there is a section 3, A to P, and section 4. It should not fall under this section 3 and 4. So importance for health related, there are mainly 4. For pharma, any product what you are claiming, it should not be a new use of a known substance or new form of a known substance. These are the 4 which sections which I am going to deal. They are mainly related to a health sector. So if anyone is claiming for a product which is a salt or polymorph of any compound existing, so it should be more therapeutically efficacious than compound, then it is patentable. And if you take the new use of a known substance, for example, we know that paracetamol as an antipyretic agent, we know that. If someone says that its new property he identifies, no, it is anti-hepatic also, anti-cardiac also. So if you want to patent that, you cannot patent in India. You can patent a formulation for anti-cardiac or anti-hepatic, but you cannot get a compound per se because it is already a known compound. So its new use, you cannot patent it in India. So these are some limitations on a health products, especially pharma products. This section 3D will deal with any new forms, whether it is isomers, polymorphs, crystalline forms, anything for a molecule, you cannot get a patent unless it is having a therapeutic efficacy over the known compound. So you cannot patent it. And when it comes to a admixture, Any A and B I am mixing. A is known compound, B is also a known. If I am mixing, it is only a admixture. So it should not be admixture for a patenting it. It should have a synergistic effect. So a substance, just mere admixture, you can't get a patent unless it shows a synergistic effect. So that synergistic effect you have to demonstrate with the results. So A's activity you have to take, B's activity you have to take, and combined activity you have to take. Combined effect should be more than individual effect. If that is the case, then you will get a synergistic effect and it is patentable. So like example, polyherbal formulations. For COVID, we have got a lot of herbal formulation patent applications. But in that, those are granted which show the synergistic effect, which are not showing synergistic effect. So you can't get a patent for that. So again, you can file any type of application. We accept the application, but we will grant only those who are synergistic effects. And the most important is that for that, any methods of whether it is medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or any similar treatments of human beings or similar treatments for the animals are not patentable. So this is the limitation in Indian Patents Act for a health sector. Whatever the doctors they use for to treat the patients, any name you can call as a doctor, whether it is a Ayurvedic, homeopathy or allopathy, any type of doctor. So they are, whatever the methods they are using to treat a patient is not patentable in India. But there is no limitation such in US. You can get a patent in US patent office for a, like example, method of heart surgery. So bypass surgery, you can do it very quickly and with a technically advanced surgery method. Those methods you can get a patent in US, but in India, those methods which are used to treat a patients, you can, even though it is new method, new protocol and inventive and industrial applicable, in a hospital industry it is useful, but you can't get a patent for that because of there is a limitation. So this is just to protect the hospitals, they are the commercial entities, and to protect that there is a patent safeguard. So if we are giving a patents for method of treatments, all doctors they have to see that whether I am infringing any methods which is patented. So to safeguard them, there is a limitation that all the methods which are practiced or which are used by the doctor to treat a patients are not patentable, including diagnostic methods. Whatever the techniques you people use for diagnosing a disease, whether it is symptom based or test based, anything, so you can't get a patent for that. So not only you, anyone will not be patentable because they are freely usable in India. So there is a demand from so many companies that so you have to amend the law so that all these methods are to be patentable. Maybe in future, in next 5 years, there may be a chances that we may amend the law to include that patents can be obtained for the method of treatments also. Because in US, we see lot of inventions which are patented in this area for a treatment, whether it is medicinal, surgical, curative, therapeutic, prophylactic, vaccinations, all these things they are patented. But in India, we are right now we are not giving because of this section 3I. So even for animals, any treatment you are doing for the veterinarians, they are doing for economic significance of an animal, they are not patentable in India. But so please don't discourage all the products, whether it is a drugs or devices, medical devices, all are patentable if it is novel, inventive, industrial applicable. Only methods which are used by the doctors is not patentable. But protocols for in the laboratory, they are patentable. So it's not to treat a patient, that is only restriction. So it's not all restrictions are there for whatever we do in the health sector research. It is only a patient treatment is the restriction. So that restriction is not there for the in vitro methods. If you are developing any method in vitro, you can still get a patent. Any in vitro methods, even including in vitro treatment methods in the test tube. So you can get a patents. And the last one is the traditional knowledge. So any traditional knowledge already there, like Ayurveda, Unani, Siddha systems of Indian medicine, or for that matter any country's traditional knowledge which is already in a public domain, not by virtue of documentation but by virtue of it is already there, so that is also not patentable. So these are the limitations for health sector, especially method of treatments or the drugs, new forms of a known substance or new use of a known substance or admixture of a substances, drugs, you cannot get a patents, or traditionally known drugs. When sir was referring, morning Vice Chancellor sir was referring about the neem patent. So you might have also heard about the turmeric patents. So in US and in Europe, so one case is there, you can Google it, you can get. So turmeric, that is use of turmeric for wound healing. It was patented by someone in US, not in India, because it is a very much known traditional knowledge in India. We cannot grant it because there is a restriction of the traditional knowledge. So this turmeric powder in wound healing, this is the US patent number, so which was granted, so opposed by CSIR government wing. So it is, the claim is revoked for that, but still patent is exists for 0.9% neem mix, that coconut oil plus turmeric is there, 0.9% turmeric powder. So that patent is exists, but that claim for the use of turmeric powder for wound healing is revoked. And the second case, the European patent which was granted for neem oil formulation as pesticide or insecticide, that formulation was granted, which is completely revoked. A NGO by Vandana Shiva, so they opposed this neem oil formulation as pesticide patent in European Patent Office, and it was revoked by after the representation, because it is a very well documented traditional knowledge in India, neem oil usage by the farmers, so it was revoked. So these are the traditional knowledges which you can't get a patent, whether it is a for agriculture or whether it is a medical profession, so you cannot get a patents for them. So I'll just move on to now the next topic, which is design. First I'll look into the designs, then I'll go for the copyrights. So design, as I have said in the morning, so it is a shape, configuration or pattern or ornament or composition of lines or color combinations. They are applied on 2D or 3D. So they are the aesthetic look, whether it is ornaments or in the fashion designing. So the term of design is 10 years generally given and plus 5 years extendable if you want. So there is a design of an article. Any type of article you can get a design registered. Anything which is new, you will get it. You don't require inventive here because there is no technology here. Just develop like sofas, you have developed it. So it is a new design, you can get a registration. Watch, cycle or mask, even mask designs also so much registered in Indian Patent Office, in a Indian Design Office. So in design, the peculiarity, you can get a set of articles also. So some articles which are having a set, like crockery set or dining sets, so these set of articles also you can register them as a design register, not single design. You can also set even this, like jewelry set, even in set also you can register sofa set or crockery sets. So there is a possibility that in set also you can register. So how to file a design? So there is a requirement of 1000 rupees fees for individuals or the other legal entities 4000 rupees. So only one form is required here, form number 1. That is, what is the requirements here? Full name, nationality, address, and then class of the art, whether it is a set of article or single article, and priority, if anything is there, you have to fill that, and 2 sets of your design, whatever it is, you have to put in on a paper like this. You have to make a specimen like this. So for example, this is the teapot design. So someone has designed this teapot, so they have applied for a design register. So this teapot, prospective view, you can give all the views, vertical, all these things, whatever the possibility in 3-dimensional, they have to understand it. So this design you have to make like this. It can be a more than 1 sheet. In 2 sets you have to submit to the design office. You will get a, with a fee of 1000 or 4000 applicability, so you will get a registered. So 6 to 8 months it will take. Within that period you will get a design registered. So after registration you can write either REGD, registered, or RD. So you can write on that product when you are selling in the market, this is a registered design, or RD or REGD. So this is about the trademark. So now moving on to the copyright, I just wanted to tell on the copyright. So little bit elaborated. So in copyrights you can register 6 different types of works. Copyright will protect the copying of original expression. It's only copying. So this applies for the 6 different classes of works. It may be a literary work, artistic works. Literary work means novel, story, or textbooks, whatever the books, even subject books, anything you are writing, a literature, what we call it as. So all those are copyrightable. So copyright is by default. Once you publish it, by default it is your registered, it is copyright. So you want to register it, you can register it. The difference is, once it is by default copyright, you can have a civil remedy. But once you register, you can also opt for the criminal prosecution of those who are infringing. So there is a difference between the registration without registration. So this literature, literary works, artistic works like paintings. So you can also register a copyright for your paintings. And then drama. So if people in a college or anywhere you have played any skit or dramas, that is recorded and you can put on a digital content, that is also you can get a registration. And musical works. So all the music, whatever that is composed, lyrics, all these things you are composing, so you can get a registration for that. And sound recordings, broadcastings, all these things also it can be registered. And cinematographic works, movies, serials, all these things can be registered as a cinematographic works. So these are the 6 different types of subject matters you can copyright it. So in this, who is the owner of the copyright owns? All these literary, dramatic and artistic works, they're the author who has done that. And in music work, who has composed that music? I was telling about the Ilayaraja and that. So who has composed that music? So he will become the owner of that music. And in artistic works, other than photography is also artistic work. So other than photography, it is the artist who has done. But in photography, the photo who has clicked the person, he will become a owner of that. So the author or owner of that copyright will be a photographer. And in cinematographic works, whatever the movies nowadays which are released, they are all copyrighted, because they will be floating on a digital platform. They need protection. If it is anyone can copy and sell in the digital content, very easy. So that's why they will definitely copyright it and then only put on a OTT platform or some other platforms. Otherwise it will be a dangerous. So there it is, the producer is the owner. And these works, whatever the works, whether are literary, artistic, dramatic, all these works, if anyone does digital content with a permission from the original author, so the owner for that, who has digitized that, he will become the owner. So like in OTT platform, if any producer gives a rights to that OTT who is hosting that, so the OTT hosting person who is making digital through internet, he will be providing a service or content to that, so he will become a owner for that. So these are the difference in ownerships for that. And what is the timelines for the copyright? Here you have, for literary, dramatic, artistic works and musical works, life of a author till the death of author it will be there, plus 60 years its validity. After death of a person who has created these literary, artistic, dramatic and music, so it will be 60 years. The legal heirs can enforce that. They can enjoy the right for till 60 years after death. And for cinematographic films, movies and sound recordings, all this, there is a 60 years from the date of publication. And broadcast, the television broadcast, all these reproduction rights, they will exhaust after 25 years from the next year, it will be counted publication. So today any serial broadcasted, so it will be having a broadcasting rights up to 25 years. No one can broadcast that. If it is there, they will be infringing. And the performance rights, it's a 50 years period. Whatever the performing artists' rights are there, till 50 years no one can copy them. So this is the timelines which are given as per the Copyright Act 1957. So how to apply a copyright? So if you want, this is very simplified. Design and copyright almost similar. In design, you need to make a one perspective view and the other views in a 3-dimensional structure, but that is also not required in copyright. You just have a form number 14 and it should be filed either by a person, in person you can go, or you can post it by or through e-filing also you can do it. So and payment can be made either online or through post, means you have to pay the demand draft. So the fee required for filing for literary, dramatic, artistic and musical works, it is 500 rupees per application. How many applications you will file? That much fee. So it is the 500 rupees fee is levied on the literary, dramatic, artistic, musical works. And if the artistic work is on a three-dimensional article, if it is an article like painting on a teacup or all these things, you want to register it, so you will take 2000 rupees. And same thing, sound recordings, 2000 rupees. And cinematographic movies or the films which are want to register by a producer, they have to pay 5000 rupees per movie. So these are the fees. So this is about different types of IPR and their procedure to apply. So I'll just for 5 minutes we'll look into the quiz. So find the famous trademarks in this. Can you just name them? Yes. Amul is there. Dettol, Cadbury, very good. Pepsi, Bata, very good. Yeah, Amul is, she has already said. Babool, very good. So Babool is there. Pepsi is already said. Is there anything in fourth column? Horlicks, very good. Any other things? Tata. Yes. So yes. Lux. So these are the brand names you can see as a trademarks. They are there. So except link, I think all covered. So this is the link LINC. This is not told, but apart from that, Amul, Pepsi, Tata, Horlicks, Cadbury, Lux, that's all. So now you have created these things 1, 2, 3, 4, 5. So which type of IPR you will obtain? First, what is the IPR you will take? Painting. It is? I want to hear from them, sir. So anyone, which type of IP you have painted? Mona Lisa painting. Beautiful painting. Copyright, very good. So second, it's a statue which you have created. Very good. So which IP you will own? It's a three-dimensional structure. It is? There are 6 IPRs I explained. Among them, one of that or even more than one, you can take it. It is? What type of IP will protect this statue, three-dimensional structure? It is beautifully designed. Very good. Someone said it is design. So it's a beautiful design. It will attract the customers. That's why you will take the design. Third one, design for the body of a laptop or mobile, and trademark for the half-cut apple. So inside processors you can take a patent. Lot of things you can own in them. Fourth one, Bisleri trademark. Very good. So fifth, that is bottle and the name. So design for the bottle and the Coca-Cola name, you can take a trademark, even copyright it also you can. So you have done an IP as a painting. So which IP you will protect among them? It is copyright. So any work done by the fashion designers, it is design. So if anyone among you has developed a advanced disc brake for the bike, it is a technology. So disc brake, it gives a technical advancement. That's why it is a patent. And among this, I explained about GI. So among this, what is the GI? Nagpur Orange. It's a registered GI. What does trademark protect? Very good. Logos, names, and brands. This is easy. 20 years. Copyright. Very good. So you all got it. I just wanted to test whether you people understood or not. So a range of clothes which is made, you want to sell them in the market. Design and mainly for selling the name, trademark. So trademark is the protecting that company or the brand. Again, new technology, patent. So thank you all for your patience hearing. So any questions means I'm happy to answer you all, or in the afternoon there is any interactive session is there. So we'll like to explain patent procedure and what are the doubts you people are having. So hope you all understood overview of IPR and other IPR forms and what is the difference from patent to copyright and copyright to design. So because many people will often get confused with everything is patent. Even media writes that when Tirupati Laddu is registered as GI, so in even Times of India has wrote as a headline, Tirupati Laddu patented. So it is a conveying a message, but in a wrong message has been conveyed. It's not a patent. It is a geographical indication. So you have a lot of difference between when it comes to a protection, it has a lot of difference from one form to the other. So that is what the aim is, that you need to understand and what type of work you have developed, what type of creation you have made, that type of creation you can protect as patent, design, trademark, copyright, GI or SICLD. So that is how you need to be aware of that. At any stage of your life, you can create and you can own it. So thank you all for your patience hearing. Sir.
In the geographical indication, we saw that Bengal versus Odisha.
Yeah, Rasgulla.
And now you are saying Nagpur Orange.
Yes.
And similar, so there is, on one hand, we say that it is societies that can claim. So once we have a state issue, somewhere we have a regional issue still. So what, can you detail that?
Yeah, see, this is definitely Bengal Rasgulla. If called Rasgulla is a natural, not a natural product, it's a man-made product. So man-made products, see, even in Belgaum there is a Kunda. So they can manufacture even in surrounding other districts also, they can. So, but there should be some characteristics associated with that geography. So here the Kunda prepared at this place, conditions which are existing surrounding that area, it will give a different taste. It gives, so that is what we test at that place. So if the orange grown at the Nagpur region or the Vidarbha region, whatever it is there, so there it is associated with the some characteristics. So that is why that characteristics were verified. See, we are comparing that the taste and the goodness or the quality or the storage ability, whatever that is there. So they will test and after that only they will register. So if that is the area where the farmers are growing that Nagpur orange, in that area, it has a special taste. So then it will be given a registration for the GI. So it has been tested and given as a register, like dal, that is Togribele. So in Gulbarga, it is also registered GI. So it is a peculiarity of that soil which is contributing, like Basmati, which is grown at Punjab area. It is having a much aroma compared to the other region grown Basmati. So after that only it is. But in Rasgulla case, it was Orissa was claiming it is our preparation is better than that Bengal preparation, or it is originated at Orissa, not in Bengal. So it has been acquired by the Bengal. So that was a different context actually. It was not for the taste and all. It was the context was our preparation is better than their preparation, like that. So maybe taste same or the quality may be same, all these things. So at last I think Bengal has won and it has taken the Rasgulla registration for that. So it is the state to state, there may be a differences. Even Pakistan has dragged India to an international court of justice for the Basmati. So because even a Punjab, a region in the Pakistan wanted that we need to get a Basmati registration as a GI. So it is the natural products or the artificial products, whatever it is, like Dharwad Peda is there. It can be prepared with the same method at any place. But this place preparation may have some peculiarity or the taste. So that only makes the GI. Any other questions?
So I wanted to ask that what is the limit for patency? Like in how many countries we can patent at once?
So you can patent your product in all the countries of member countries of Paris Convention. That is 193 countries on the globe. So that is the one possibility. Or PCT, if you are going through 156 countries are members of the Patent Cooperation Treaty, you can patent them. But you need to see whether the market is there for that product. For example, if anyone develops a drug for control of malaria disease or vaccine for the malaria, so you need to focus only in the tropical countries where the mosquitoes are there and malaria spreading is possible. You cannot go and patent in the this cold countries. There is no possibility of a malaria. So you need to look into the commercial interests where my product can sell in that country. You can take, if you possible, all 193 countries you can take it. Like this laptops, mobiles, they are there in every country. They are patented in all 193 countries. Wherever the possibility that patent is possible and protection is possible, they are going and taking, like Apple I was saying. So it is not the decision has to be made by the person who wants to patent, because it involves the cost also. So how much cost you can borne, which are the major economies, you can patent it, you can patent it. Like generally from India, they will say India, China, Japan, like, or US, Europe, they will limit these things. So otherwise you can patent theoretically in all countries wherever the possibility of commercialization is there.
So for exercise, if we are developing a protocol, so that we can do it for copyright.
Yeah, so this is a good question. So copyright, you can do it for anything. Even I have on a piece of paper, I have written some even no meaningful things also, you can get a copyright, because this should not be copied by others. But in protocols like laboratory protocols of doing some surgery or these teaching methods or teaching tools, anything you have written A, B, C steps, these protocols, it will not protect that A, B, C, D steps. It is only protects the copying how you have written that. If someone sees that copyrighted information and does the practical work, it will not protect that copyright. So for the protocols, you need to go for the patenting it. If it is a new protocol you have developed to do something, surgery or some experiment, so you need to go for the patenting of them. So copyright will only protect the originally how you have written. If it is written in italic, it will protect that italic. Like that only it will. Not the contents will be protected. It is the way of expression it is protecting.
So we can apply for patency for the
Yes,
access
all the
protocol.
procedures. Say, as a science students, you need to look into the patents for the products or processes. Whatever it is, new and inventive, you can go for the patenting, not the copywriting.
Okay, sir. And so, like, once we are registering into one country, so at the same time, can we register in another country also?
Yeah, that is possible. See, for an international application, today if you file even at Chennai office or any other office in India, through by sitting at Belgaum, you can file it. It is as good as it is theoretically possible that you have filed in 156 countries by sitting here in Belgaum. And for getting a patent, you have a 30 months or some countries 31 months. So you have to go within that time, you have to file for the grant of a patent in that country. The priority is protected. Today's date, it will be protected in that country. If you go to that patent office and ask within 30 months.
So, sir, like, we can get the patency in 30 months.
No, not 30 months. Filing time period.
Filing.
You can get within 8 months also. There is a expedited examination. I will explain in the afternoon how to get a quicker methods for the getting a patent.
Okay.
Okay.
Thank you, sir.
Yeah. Yes.
So, like if we have done a patency and we get to know that someone has copied our design or something, so what is the first step we take? Like, where do we have to go and complain or something?
Yeah, not complaining. Patent office will not help. We are only registering authority. So we are not going. So you need to know that you have to go and catch and you have to send a legal notice to them. Now I got a patent. For example, X product, I got a patent. So now the same X product someone else is manufacturing and selling. It's now my duty to send a legal notice. So and so patent, I have got it. So if you are selling it, you will be infringing my product. So if you send a legal notice, there will be a time limits for responding to that legal notice. So if he is not responding, you have to file a case on him. There is an infringement suit. It will start from the district court. It is possible in district court or in high courts. Wherever it is possible, you can file a case on him. So when court sends a notice, he is bound by the reply. If he is found that he is infringing, so court will avoid a damages. Whatever the loss you got as a owner of a copyright or patent or anything, so you will get that damages. Okay. Yes. I think.
Sir, if we are developing a scale or questionnaire, so can we apply for the patent?
Questionnaire, generally it will not be any product or process. If there is a teaching tool as a kit, you can say it is a product. So but in questionnaires, it's like feedback form or questionnaires or whatever you are asking for the patients or customers, whatever it is, so they are only copyrightable. These questions should not be copied by others in this format. Whatever I am writing, first question this, second question connected to the first question, third question, so these are only copyrightable, not the patentable.
And for the scale?
Scale, if it is that scale is useful to assess, like
It is for
diagnostics or all these things, they can be, if it is there in the diagnostic kits as a scales, so they are patentable as a product or method for preparation of that diagnostic kits. If it is new and inventive, definitely you can, scales can be used in the kits. So that kit as a product or kit manufacturing method, you can get a patent.
Thank you, sir.
Yeah,
So-
year, yes. Year one question is there now. Are we late? No.
So, if you
Yes.
have developed a device and it is used for diagnostic purpose.
Yes.
So we can patent that.
Yes.
And the procedure for which, like the procedure that there has to be certain procedure to use that. So can we copyright that procedure as well?
Yes, you can. So, or I can say in other way, user manual for that device. Every device is having its user manual. Like we purchase a mobile, they will also give manual for this. So that manual is copyrightable. No one should copy that manual. So it is copyrightable.
So the procedure for it will be different.
Yes, it can be copyrightable. So very much it is. So, but what I mean to say that device and device preparation method will be there, fabrication method. So these can be patentable. These are technology.
Sir, as you said, like every country has a time period. Like if we patent it in India today, and within 30 months, for example, in some countries.
Yeah, international route that is within
international
30
route.
months.
And if we don't do in within 30 months or something like the time period given by that country, then what happens after that? If we go for patenting in that
After 30 months, if you go, your priority will not be protected. So here, whatever the Indian application you are having, a first application at one patent office, today on 4th May, so you have 30 months. After 30 months, you are going means, because the treaty is having a this much time limits. After that also you can file it, but they will cite your own application which is published as a citation for that. So it will lose the novelty of your invention after that priority. So if it is priority means, they will date back whenever you go, even after 29th month you have gone, as good as you have filed on the first month itself. So that is dating back to that date. Anti-dating effect will be there.
Sir, if we patent it here and we are not patenting in any international country or other
Yes.
country, then are they applicable to patent our thing in their country?
No, it is not enforceable. This is what territorial rights. If I have a X products patent in India, I am not taking any patent in US. So the US, anyone can manufacture that product and sell in that country. Only restriction is that they cannot export it to India, because India you have a limitation or enforcement. So that is what the territorial rights. So if you are protecting in US, so US also you can enjoy. No one can import into US also possibility. So they cannot, even Chinese, they cannot export to US. So that restriction will be there for that. Importation is also prohibited.
Thank you.
Okay. So once again, I thank University Care Institute and the JNMC, or all these people who are organizing this workshop. And special thanks to Vice Chancellor and Registrar Sir and all the Dr. Anil or Dr. Ugar Sir, who has given me this opportunity, and all this whoever wanted to learn. So a big thanks to all of you. I think we hope interactive session I can take more questions in the afternoon session. So thank you.
Thank you, sir. Thank you for the wonderful lectures on the IPR and patents. Now we shall break for the lunch. I request all the participants to get back here by sharp 2:30. Thank you. A very good afternoon to all. I request all the participants who are sitting, please come and occupy the front places. It's an interaction session, so please come forward and sit. From this side also.
Hello, Chuck. Good afternoon. We'll be shortly starting with the third session of the day, and this session is planned more to ask questions to the resource person. If anyone is having any of the ideas or any stage of IPR, if any of your research is there and it has got stuck in some of the IPR cell or patent office, you have all the privilege to ask questions to the resource person and clarify your doubt. Because morning we had very good questions from faculty, PhD scholar and postgraduates. Now the Indian Patent Office patent officer only in front of you. If you have any doubts, if you want any clarification or you want any suggestions or guidance, you can ask questions and make it more interactive and go through the steps of applying for various types of IPR, because that is very important part and it is a futuristic of research in India. Okay. With this, I request Dr. Manjunath to welcome the resource person and start the session. Thank you.
Good afternoon, all. Good afternoon to online participants also. It's a kind request that every participant should mute yourself, so not to interrupt. With the afternoon session, we'll begin with the hands-on and interactive sessions. Already Shivogi sir has explained. So I kindly call upon Dr. Sharan Gowda sir to conduct the hands-on training and interactive session of IPR.
Good afternoon. So I understand it's difficult after lunch to this IPR session, but still I will try to maximize the interaction with you all. So I'll just share few slides. So on practical aspects of, so morning 2 sessions we have dealt with the theoretical aspects. So I thought, so some practical aspects may be required. So when you people are going to file any invention, whatever the creations you people are doing, so you require to have the tray training or some knowledge about how to file a patent applications. Yeah. Okay. So morning I said you need to first innovate. That you people are anyhow you will do a creations. How that creations can be filed as a patent application, because the patent office whole system will works in these steps. Whole office, there are 4 offices located at the metros of the metro cities. So they work with all this. First and foremost, filing of patent application. That is done by the public or any researcher, any innovator. So who has created it, they have to do the filing. I will give brief how you can file a patent application on that. And patent office work will start first step publication. So that is the literal meaning of patent is to lay open to the public. So that is the Latin word. So lay open to the public. So that's why our first work at the patent office starts as a publication. So there are 2 types of publications. One is early publication. Another is the 18-month normal publication. So early publication, which is within 1 month we publish if you are in need of urgency. For that you need to pay extra fee, and one form is there, form number 9. So if you file, it will be within 1 month. Nowadays we are publishing within 1 week. So then after publication, any third party, there is a patent office, you have given invention to the patent office is a, because you have created, you are the first person and you know what is creation, you have given to the patent office is a second person to come to know that creation. Now after publication, third parties, anyone can oppose that grant of a patent to you. So they are third parties, that is a pre-grant opposition. Before grant, anyone can oppose for a grant of maybe some controversies or sometimes collaborators, the 2 people were working for the project. So one person only filed the patent because he knows, both knows, but the other person's name is left off, he has filed it. Now the remedy is that, so once published in the other person's name, they can oppose. No, I have also contributed to this invention. My share should also get into that. So like that, there may be so many issues. So they can be sorted out by pre-grant oppositions. Whether opposition is there or not, our examiners will examine that. And if it is merit, it will grant. If it is not merit, then objections will be sent and time limits will be given for you to sort out the issues. After that also, if it is not sorted out, we will call for the personal hearing through the video conferencing. No physical interaction at the office. Now we have completely stopped the physical interaction coming to the patent office. Only video conferencing, we will send a link. You have to come online at the given time. So you can discuss about that file, 1 hour or 2 hour, whatever the time it will take. So you can discuss on that. So we will suggest so many things. If you change, so it will be granted. So that is the general practice as the patent. That is, we call it as a examination. So once it is granted, after that also it will go for the publication. Again we publish to the public, so and so claims are granted, product or process or both it can be. So they are granted. So if anyone is using, they will come under the infringement. For that we do second publication, that is grant publication. So after that, any interested party, anyone is harmed by the grant of that patent, anyone is doing the same field research, but he knows that, so now this person has got a patent, so he can oppose that, but only interested person can oppose. Any person interested can oppose, not anyone. In pre-grant opposition, anyone, but in post-grant, it is any person interested. So there are minimum 4 forms are required. You have to prepare. To get a grant of a patent, these are least minimum 4 forms. There are 30 forms in the patent rules. In that, at least 4 number of forms you need to file it. So that is the minimum. So that is form number 1. It is application form. Like when you want to take admission in this medical college, so you might have filled the application form. The similar, that is the application form. Who is the applicant, what is the nationality, what is the residentialship he has having, and what is the correspondent, that address. So applicant, inventor, all these details have to fill it. So there may be a applicant and inventors may be same, applicant and inventors may be different also. So these are the form number 1. So the invention where you have to write is the form number 2. That is provisional or complete. You can file either provisional or complete. The form number 3, statement of undertaking for the foreign filing. So as I said morning also, we had a discussion, you can file any country. So whether you have filed anywhere outside India, you have to declare in that form number 3. For example, I filed in US, Europe, China, Japan. I have to declare that with the application number of that countries. So this is for just reference of a controller. So if it is not filed anywhere outside India, it is a nil statement. There is no filing. Nil also you have to file. 1 page form it is there. You sign and you can upload. Online means you can upload it. Digital signature. So that is, and the 4th one, request for examination. Form number 18. This is the form number 18 required because you want to get an examination from the patent office. See, if you don't want to grant, just I want to get a publication in the patent office journal, you just file form 1 and form 2, you forget it. We will publish it in the patent office journal in your name. This is just an academic interest. No, I want to grant, I will try for, if anyone is, companies takes over my patent, I will try for the commercialization. So then I need to go for the form number 18. So there is a maximum time allowed is the 4 years. 48 months we give you to file a form number 18. Within that you have to file. So today if I file an application with a form number 1 and 2 and 3, so I will get 4 years from today. So that is 27, 4th May 2027. Up to that you have a time. So within that period, if you are not filing, it will be deemed withdrawn by you for the grant of a patent. But publication will stay in the public domain. So that is there. So that is the 4 forms, the different fees for that. So form number 2, you can file either provisional or complete. Provisional means it is an idea. So by sitting here in the hall, you got an idea to develop something. And you may have a doubt that before I file a patent, someone else may file. That's why I want to preserve my date. So what you need to do, you write your idea in 1 or 2 pages and file a application that is called as provisional patent application. But keep in mind, provisional will never get a grant. So within 12 months, you need to file a complete specification, that is form number 2. Complete specification with all the details like this. What are the details required? So title of the invention. First and foremost, first page will have title of the invention and applicant and his nationality along with the address. There may be a n number of applicants. 1 is minimum and it can be a hundreds. You can file either one person or 10 persons or 100 persons, but one is minimum applicant is required, because to whom we have to give rights. So at least one person name should be, either it is a institute or JNMC can file or Care Institute can file, any name you can file it. So or natural person who has invented, so they can file, or together with the institute they can file. So in any way you can file it, so but at least one name is required. So title and the applicant name will come on the first page. Second page onwards, field of the invention will start. So which relates to what field. So title of the invention should not be more than, generally, ordinarily, not more than 15 words. So that is precisely we suggest to use up to 15 words, not big title. So we will not explain lot of things. Broader title and precisely it is indicating the subject matter, it is sufficient. And field of the invention. So 2-3 lines you can write what it relates to a field. It may be electronics field or biotechnology or medical, pharma, anything it can be. So background, the literature you have surveyed through internet, so many citations you might have got earlier one, you can just write about them in the background. And important is the advantages you have to write. So why my product or process is advantage to the society? How it is advantageous, you need to write. That will help you deciding inventive step. So it is ready-made information, you can file it, advantages. So some advantages you write one, at least one, you can write 10 number, 15 number, any number, that is the advantage. And objects, what is the object, whether it is a project, product or process, all these things you can make as objects. And statements and detailed description. The important is that this detailed description with working examples or the flow charts or diagrams or figures, they are must. If you have like chemical or biotechnology, working examples are mandatory. If it is a mechanical device or instrument or surgical device, anything you want to claim a patent, so its figure or drawings is a must. You need to give the drawing and their explanation. Without that we can't grant it. So all the details should be given. You can interchange these headings. This is just I have given, this is not as per the act. So you have to describe, in generally we see these type of subheadings in the patent application form 2 complete. So here you need to give some working examples, at least one sample preparation or one sample diagram, that will help the examiner to understand your, because here in patent, because I am selling in with my 19 years experience, what you do in the lab is not much important for a patent examiner. What you write in the paper is much important. You might have done a great noble work, but if you are not writing in a proper way to convey that invention, we never understand it. And many inventions we are not granting because we don't understand, or sometimes they have not written properly. So writing part, whichever is written very good, we will grant very quickly. So how you represent on a paper, it matters for us. If it is, I understand very fastly, very quickly it will be granted. Nowhere it will stop. If we are not understanding, we have to take help of some others to discuss, and then it will be time lagging. That's what it happens practically. Of course, we should not delay, but sometimes if I am not understanding, it is, we will keep side, okay, we'll see tomorrow, we'll see tomorrow, like that it will be pending. So that is why the representation on a paper is a most important part. You want to get a quick patents from the patent examiner. And the important part is the claims. You have to write at least one claim. You can write hundreds, but 10 claim, after 10, the additional fee will be levied on you. So, and the one just summary or gist of the invention, you can write it as a abstract. So these are the practically you have to give title, field, background, object, statement or summary, detailed description, claims and abstract. So these things are required as a complete specification. So if you are writing properly all these things, within no time you will get a patent. So as I said, quickest is the 8 months. You can get a patent within 8 months. Otherwise, there may be some delay in that. So how much fee is required? So fee to be paid to the patent office is 1600. Form 1, Form 2, Form 3 are covered, and Form number 18, 4000. So either you file 1% or 10%, it is the same fee. There is no difference of the fee. If the educational institutes, who are all covered in the 1600 plus 4000? It is the natural persons, startup company or companies, small entities, then educational institutes. All these 4 types of persons are covered under the 1600 plus 4000. This online filing. If it is offline, either by way of post or coming to patent office and filing at the counter, it will be 10% additionally levied. Paper filing will be levied with 10% extra to this 5600. So we encourage online filings. So other than these 4 types of persons, like large companies, they have to pay 8000 plus 20,000 online and 10% extra for that 28,000. So this is the fee. If you are filing form number 9, early publication, you want quicker publication of your invention, I want to bring my invention in public domain very fastly, then I need to pay file the form number 9 with a 2500 for these 4 persons. Other than small entity, they have to pay 10,000. So it is the fee, form number fee, 9 fee. So these are the minimum requirements for a patent application. Form 1, Form 2, Form 3, Form 18 with a fee of 1600 plus 4000. So if you are and you want a very quickly patent, so if you are covered under this category, not all can file. So startup companies, they are welcome to file a expedited Tatkal Seva. It is India as a international search authority you have selected, and all are natural persons. Inventors are, other than inventors who has filed, natural persons. In among them, at least one woman applicant is there. At least one woman applicant. If all are there, they are eligible, but at least one woman applicant, they are eligible for the expedited examination. Or any government department or institute, state or central, they are all eligible. So there, apart from those 4 forms, there is a requirement of form number 9 and form number 18A. Instead of 18, you will be filing 18A with the extra fee, that is 4000 will become 8000. I said 1600 plus 4000, now 1600 plus 8000 it will be. And no offline possibility for the expedited. Only online we accept the expedited examination applications. There is no possibility for the offline filing, either coming to the patent office or by sending by post. No possibility. And we publish quickly, within 1 week it will get published, and within 1 month we issue the first examination report if any objections. If no objections, then within 8 months you will get a grant of a patent. This is the quickest time. Why I am saying 8 months? Why not within 1 month or 2 months? Because we have to mandatorily wait 6 months after publication for the pre-grant opposition. Any person wants to oppose, we have to give time for them. So that is why minimum it takes 8 months to grant a patent expeditedly. Whatever the speed we apply, so it will become 8 months. So any person either alone or jointly they can file. So by any person who is a inventor, primary rights vests with the inventors. Who has created, he will be the first owner for that. If he is transferring, others will get. Otherwise, he will become owner for that patent if he is a applicant. So any person who has invented that, he can file a patent or he can transfer. Like you people are working here in this institute, JNMC or Care Institute. So you can transfer rights to the institute. Institute can become owner of that patent. You still be, you are the inventors. That is the first category. You are having a full rights. You are transferring. You will get institute will get. The third type is the any person who has invented. He has worked a lot extensively, completed the research, but before applying to the patent office, he has died. Death happens. So then in that case also, any legal hire of that, legal representative of that person can file a patent application in their name with a death certificate. So then also possibility is there. So these are the three types of persons they can only apply. Inventors or assignees of the inventors or legal heirs of a deceased person. These are the three types of persons who can apply. And as I said, there are 4 patent offices having jurisdiction. Like if you are giving address of Belgaum, so then you have to file at Chennai patent office. Karnataka comes under the Chennai. It's depends on the whose address you will give, applicant address, where it is, first applicant address, which state. So if you are filing online, you enter a pin code means it will automatically takes the jurisdiction. Immatter, it is immaterial from which jurisdiction it is. So online, virtually. And if you are from Maharashtra, then Mumbai, then if you are northern part, it is New Delhi, and any state which is not covered in this, it is rest of the states are covered under the Kolkata jurisdiction. I have prepared form 1, form 2, form 3, form 18. Now how to file them into the patent office. So there are 2 ways, electronic filing or physical filing. There are 2 methods you can. First, in the e-filing, there are again 2 types of e-filings are there. One with the digital signature certificate. So if you are procuring digital signature certificate with a pen drive, you can just put a pen drive and certify that all the documents, our website accepts that. So that is digital signatures. Or e-signature is also a possibility. So you can file through the e-signature, OTP based. You have to enter your Aadhaar number. So OTP will come if you are entering, that e-signature of that documents will happen. So these are the 2 possibilities in the e-filing. Whichever so for e-signature it will be cheaper. I think you can get 100 signatures in 250 rupees. If you pay 250 rupees, you can sign 100 documents digitally. But in DSC around approximately it costs you around 5,000 rupees. So and renewal every year you have to do. So that much is the fee. And for patent agents, it's mandatory that they have to sign with a DSC only. They don't have any option of e-signature. Only applicant is having. So applicant is also having physical filing, offline filing is also possibility. Offline also 2 types. You can come to the patent office, hand over the documents with a fee, cash, or through the electronic transfer, you can do at the counter, either through PhonePe, Google Pay, whatever the possibility, you can pay it at the counter. Or you want to send, by sitting here also, you can file it through the post. Speed or ordinary or register, whatever the office, no DD, no courier is acceptable. So courier is not acceptable by patent office, but you have to file through the post only, India Post, we accept the documents. So you can, but when you are sending through the post, we accept only demand drafts payable to the controller at Chennai, Mumbai, Delhi, whatever the jurisdiction you are having, you have to write and you have to send it. So these are the options for physical filing, by hand or by post. So if after filing, we process the application and we send if any objections as a report, compiled report, examiner will send a report to the controller will communicate. I myself communicated to one of the application. So there the objections like this sheets, summary report is there, part A, and part B detailed report. So in part A we say some of the claims are novel, some of the claims are not novel, and some of the claims are not inventive. So we send a report with all the details of citations. So here is summary report, and after this you will see there is a detailed report also from this novelty. So there are 7 citations given, patent and non-patent literatures. So 4 patent citations and 3 non-patent literature. So we have provided when it is published all the details. So you have to open these documents by copying into the Google. You can get all the documents. No need to pay anyone. So just you copy the number in the Google, you will get that. So those documents which are cited here, generally you will be free of cost, you will get it, documents. So you can just go through that and compare your invention. That is what we want to, we expect that you have to do. Don't be frightened or don't be discouraged. We have given so many documents. Sometimes even some documents may be irrelevant also. So, but we have got as a keyword search, we have got in the computer, we will cite it. Sometimes if your examiner does not understand also, the citations will be different, will come. So it's now because you have done that creation, innovation, you are in a better position to understand both citations and this. So you have to make a difference and then file a reply. So we give maximum time of 6 months, which is extendable by 3 more months with a fee. 6 months is time is there, you have to file the reply, and 3 more months you can extend it. So that is the, so this detailed report, how it is, novelty is not there, how inventive step is not there, all the details are explained here. You have to go through that and make a reply to that, and you have to send it to us. All the objections, whatever, unity of the invention, then sufficiency of the disclosure. So disclosure, it is not sufficient, all these things, because sometimes applicants maybe they might have done this much invention, but they will want to claim prior art also. So that much it is not described like that, we will give. So then they will narrow down the claims. So these are the formal objections, only one is there in this, the formal requirement. Sometimes there may be more also. You have to file this, that. If everything is perfect, we won't send any objections in the formal requirement. So after this examination report, you have to send a reply within 6 months. If we are still not, examiner is still not satisfied, so then he will raise further objections with or maintain that objections, and then there will be a hearing for that. I said through video conferencing we will discuss with the inventors. Generally we prefer to discuss with the inventors because applicant may be different person. So inventors, they know better the technology. So that's why we prefer to so these are the hearing will happen. So here you see there is a timeline, 14th March 2023 at 12 hours Indian Standard Time, for 1 hour the discussion through video conferencing. So we also send a link to that. So at that time you have to just click on that link, it is automatically, it will open. you can talk to the either mobile, laptop or desktop, anywhere you can open. So that link through your email it will come and you can open it. You can discuss what are the objections. We send at least 1 month before these objections. You have to prepare for that objections if anything. So these are the 4 objections we have sent and they have replied orally. So they have explained it, this. So then after within 15 days they have submitted a written submissions and ultimately so it has been granted with a patent. So this is what happens. All your patent applications generally may pass through this procedure. 99% applications we have similar set of procedures. Here very well written and no objections, directly also it will be granted. But I said it is the write-up which will matter for us, because many times I have seen that the public will say that I have done a great work. They might have written in their perspective, but we expect that in our format they should write, because we have trained our examiners in that format only. Okay, here is the invention, here is the advantages, here is the claims, here is that. So we will search that. If it is not there, so we will not, oh, he has not written. He might have written some other parts because it's hard to read each and every line of the specification and then understand and then give objections. We are giving hardly 8 hours time to an examiner one case. You might have done 2 years, 3 years that creation, but examiner will get approximately 8 hours. In that 4 hours he has to read, 4 hours he has to make a report. So that much short period he has to do quickly. So errors may happen definitely. So you can correct them. If it is irrelevant, you can write it, this is irrelevant in this way. So ultimately you will get a grant of a patent. After this you have to maintain that patent. So this is what the procedure of filing and processing of a patent application. So in normally it will take 27 months and expedited route it will take 8 months. Tatkal, like we book Tatkal ticket, this is also there is a Tatkal service from patent office. Within 8 months you can get a patent. So this is the procedure or timelines, fee, documents required. So what else you want, or you have any questions? We will discuss. So mainly on this you may have so many questions. I understand. If you are people are filing generally, so this may be the difficult part is drafting a patent specification. So that is the difficult task. So you need to write title, abstract, field of the invention, all these things. First time you are doing means definitely you will face a difficulty. So I welcome if any questions regarding any of these things. So yes sir, please. Best mode of carrying out the invention. Yeah.
Inventive step and best mode of carrying out. In which section we have to mention and how to
So
mention.
inventive step is advantages of the or uses of the invention over the prior art. See, you are describing prior art in the background. So advantages over the prior art. That is what the inventive step actually. See, X product is already there. For example, there may be several drugs for the cancer treatment, anti-cancer drugs. So I am developing a new anti-cancer drug. So how this new anti-cancer drug is effective or therapeutically efficacious than the prior art. So that advantages you have to write here, that will become a inventive step. So that is the advantages are over the prior art, existing knowledge. And best mode of carrying out the invention is detailed description with drawings or working examples. These are the best mode of carrying out the invention as per section 10(4) of the Patents Act. See, you have to describe one sample preparation or sample drawing or the device structures. So if you are labeling that parts, how to assemble all these things you will write in the write-up. So anyone reading that sample, he has to arrive at the product what you are claiming or process what you are claiming. So that is what we expect a best mode of carrying out the invention, which there may be a 10 methods, but among that you have to write only one best method. Especially in chemical compounds, there may be a 4 alternative routes I can prepare that compound. But among that 4, whichever you feel it is the best, you have to describe that. Yes.
Sir, actually you said that when the two inventors are doing the work and one of them has filed the patent, but when we communication will be done with only one applicant or inventor, no? All inventors or applicants will not get the updated emails or any communication from the patent office.
Can I use internet for this? And it can. I'll just clarify you, ma'am.
I mean to say, how the other person will come to know that it has been filed?
No, I'm just coming on to that. So before that, I'll just show the form number 1 so that you will get clarification. This is designs. Yeah, this is the form number 1 from the Indian Patent Office website. So I think, so this is the form number 1 which I am referring. So you need to fill this form. Here there is a first applicant's reference number. If it is allotted, you write, otherwise leave it. And type of application. So generally, if you are first time filing, it is an ordinary application. So conventional means first they will file in US and come into the Patent Office India, that will become conventional. Or they will file international application and then come, that is national phase will become. So this is ordinary application. Third, where you need to write, so the applicants. So who is the applicant? Name in full, not in that, what is that, surname, all these things you have to write in full. We expect that you write in a full. And nationality, country of residence, and then it comes your house or office, whichever you feel you can give it. It's not that we have given house number, you have to give house address only. It is not mandatory. You can give institute address also. It is up to you which address you want to give it. Okay. So here you have given, and the first part, here maybe 2 applicants you have given, 1 and 2. The same name, nationality, address may be same, but name may be changed. That is the 2 applicants. But communication will be done to the persons who are given at this 7th point, item number 7, address for service of applicant in India. Whosever name, even these 2 applicants may give third party name for the address, care of address. They can give, and many times they employ agents, they will give the patent agent's address and their email. So we communicate it to the patent agent or whatever the address given, our website detects that and it will pick that email ID and will send a communication to them. It is first applicant, second applicant, third applicant, it is immaterial or inventor. We don't know. So whatever you write in this form number 1, for that only we are communicating the email or postal communication. If it comes, email is not there, we are forced to send a post office communication to that given address. Think one thing it is clarified to you.
Yes, sir. But
Yeah.
what I mean to say is when we publish a paper, simple paper, when we publish, we get a conflict of interest mail from all the publication, means from the journals that this paper has been sent and you are one of the co-author. If you have any conflict of interest, you can contact us back
Mhm.
that way. So I feel that it should go to each and every applicant, at least filing or application.
Okay. So for that also we have alternate email address also, you can write it. In the online filing you can include 10 email IDs also. So when we click send, it will go to all the email address whatever given.
Okay, so when we are
But-
filing, we should,
But we expect only one has to reply.
okay, fine.
So all the 10 different replies comes means we won't read those 10.
Yes, yes.
Whichever comes first, we will read that.
Got it.
So there is a communication for one. So and your other question, there may be a conflict of interest. Say two applicants filed. I was referring that two persons work together, but one person has filed. So how the other person will come to know that? So it is after publication. It is in the public domain. If anyhow he will come to know means he can file a pre-grant opposition. Or if he did not come to know, it is granted, he can file a post-grant opposition. This is my contribution is also there in this invention. It has not been recognized. I should also be considered as one of the inventor and applicant. You can give a petition. So if you are establishing that, okay, collaborative work, we will consider and we will definitely look into that. So even post-grant opposition chance is gone. You can go approach the court of law. There it will be rectified till 20 years. Yes, sir.
Sir, actually, she is speaking like in a publication, there is a corresponding author and co-authors. What's her question is there? When any person will file, okay, you can send the communication to all the inventee and you can accept only one person who is the corresponding.
That's what 7th, sir.
No. You told anybody can send the first, you will accept. Okay, but in such condition, what happens? Some inventor, they are the part of inventor that. Okay, the corresponding author, he knows entire the things. I think her question is related to like this.
That's what.
Any such things.
That's what we generally, that's why we avoid sending to all communications first. And if by chance the applicants, there are more number, I should also know that. So they have a right to add their email ID also. Because email we are not getting. Postal means we were sending only one post. Even though 10 address they have given, only one address we used to communicate. But email we don't lose any money. So we are clicking on that, it will go. So because sometimes what happens, one might not be checking the emails. Better to send it to two persons. Either of one will check. Sometimes it may go to the junk or it may spam. So many things will be there. So that's why we advise more than one email address should be given. By chance you will be checking that, you will come to know patent office has sent a communication.
Sir, one informal one.
Yeah.
When we put the keywords or any boolean, all patent will search the Google, but not Indian patent. It is at least my last 10 years of experience.
Yes, definitely.
Why you are not linked this Google search engine to Indian Patent Office? Because I can, if I put any keyword, I can get the lot of US patent and European patent and other things. So I can very easily, I can check.
Yeah.
But not Indian patent.
Yes, sir.
So it is actually one way we are hiding. And
No, not hiding. Ours is
we are
also.
not getting, we are not.
No.
The-
Through Google or through other search engines, because there is a different terms and conditions we are putting to them, so they are not agreeing, and still the talk is going on to link with them. expect that it should be explored all. So we are expecting that, so you need to pay for this to expect that you have a search engine which can be linked with our database. Because our database is maintained by NIC. So they have generally government bodies, they discuss them and it is inconclusively going on. Since 5 or 6 years, I know that it is going on that. But what I suggest is that, for example, if you want to search our patent, like you can just go to this public search at the website.
Sir, I know this, but
Yeah,
what
for the
happens-
benefit of others, I'll just show that. So you want to search patents, trademarks, anything you can do it here. So public search you can go and see here there is a patent search, patent e-register. After grant, e-register will be maintained for that, and you have application number. You can directly go to the application status here. So here 3 options are there. This is our INPAS, Indian Patent services. So these INPAS you can search here, anything you can give, the title or the abstract, complete specification, you can give the keywords. You just before that one time you can easily run this. So or you can use that R bulletin and you can search.
Sir,
Yeah.
actually, it is my suggestion. Shodh Ganga, when it comes to the open format, now most of the researcher they are helped. Okay, if this also comes to in a open format, so most of the researcher can help to
Yeah,
know.
sure. I do understand that, but so through linking with the Google, I said the constraint is through the NIC. That's why we are not able, because NIC is the maintaining software for this.
No,
So
thanks.
I do really understand that. Definitely one day it will be linked. There is a talks going on, so it will be linked with that. So if you want search, anyone can tell the any keyword. Any keyword you can, like diagnostic. In the title or abstract or specification, wherever you can put it. So you have to enter every time CAPTCHA. See, these are 1083 records are there in a published documents you will get. So this is the title, and so on that the first, it is the recent one, recent publication, and then older one. So here if you click on this, you will get a complete file of that, whatever the documents filed with that. So this is like tumor contrast compound preparation, method thereof, and in tumor diagnostic imaging. So here this is the publication, bibliographic information. So this is the applicant and that is the inventor and abstract. If you click on this view application status, so you will get a complete file, bibliographic details, and still it is not filed with a request for examination. So no examination will take. So they have up to maximum 48 months they can file it. So you can see that documents, whatever it is filed with this application. Any application number you can put it and you can check it. So with this you can do the public search in the patent INPAS. See, here is the, like you want to see the form number 1, how it is filed. You just click on that, so it will open. So this is the form number 1. So this company has filed, Chinese company. So this is the applicant, and this is PCT national phase application, and its address given here is this. This is also important, address for service. So this is the important one. At least any foreign applicant filing patent, they need to give Indian postal address mandatorily. Whether you hire agent or not, but you need to give one postal address. Though we are sending by email, you can access from the foreign soil also, but it is mandatory that you need to give the postal address. So this is having a priority from the Chinese. Within 1 year, and then in 2023 they have entered into a India within 31 months. So that is the deadline. So like that it is the filing. See, here is the international application number PCTCN 2021-114672 on 26th August 2021. So Indian filing is done after this. So this is the form number 1. So the search, you want to search any application, you can search in the website.
Sir?
Yes.
Sir, myself, doctor.
Yes, sir.
Sir, for the multiple applicants, who will get the examination report, FER,
Address per correspondence, whose name it is given.
for them?
In that name only we are. If it is agent's name, agent will get.
Okay.
You even having a agent also, you can also give your email ID. It's not harmful. Sometimes agents may not check or means you may lose. So double check. That's why they will give their email ID also. So multiple applicants means the rights are shared between them. Whenever it is granted, if there are 4 persons, all 4 are equally undivided share in the patent. Anyone can commercialize, but he cannot sell that invention. For selling, all the 4 must sign that. So, any other questions? Yes, please.
Sir, is there any other
Yeah,
separate
welcome.
form?
Yeah, please, sir. Yes, sir.
Is there any other separate form to add patent inventees after getting the patent acceptance?
Inventors.
Yes, sir. If you want to add, what is the actual procedure?
Yeah.
Either you should do an affidavit or just simple, fill up the form and send to the patent office.
So different works for the different forms are there. For example, this is the grant of a patent, form number 1, provisional or complete, form 2. So there is a form number 13. Here is the form number 13. So application for amendment of the application for patent or complete specification. Any record you want to change anywhere by mistake or by spelling mistakes including, you can correct it by filing form number 13. So this is the form number 13. So we call it as an amendment. First you have filed, even name correction is there, name change is there, like companies will merge into that, name changes. So all these things are corrected by form number 13. It is technical, non-technical. So technical, that is complete specification change. So by mistake I have written something else. I have to give proper data. Something I have copied from others and it is just reflected. I want to change, replace that. You have to erase that, delete that and add that. So you have to file the form number 13, complete specification change.
This form is holds
For all
names also, sir?
Yes,
Add the
name of a applicant, change, correction, name of a applicant, inventor name change or inventor addition. If it is by mistake, I filed it with 2 inventors, but actually there are 3 inventors. So how to add third inventor? You can just file a form 13 and say that reason for that. So we have mistakenly omitted the other third person. So now we want to send it. So you said about affidavit. Here affidavit from other 2 inventors are required because they should agree that he is also a co-inventor. If it is not, then we won't add it. Yes. At any time, before grant, after grant, but fee will be different. After grant, you have to pay double fee.
So is there any specific period to change this?
No fee specific period. So you can file before grant of a patent or after grant till 20 years completion, you can change anything in that. But the applicant change by Form 6. For example, you filed in your name and you now some other company wants to acquire from you. They paid money. So you can change them owner as them. So that is for that form number 6 is required. Applicant change. Their deed of assignment you have to file. I am here with selling my rights to these persons. So you can do, but that will possible only before grant. After grant, only assignment change. Patent once granted, applicant will never become change. So it is form number 16, you have to change the assignment. Now this person is holding, now the license or rights with this person, like that it is. Register will change. Yes, you can add at any time the applicant before grant. Form 6 is before grant. After grants, only patent, granted patent rights will change. You can add the owners after grant, but certificate will not change. Certificate is originally in whose name it is granted, it will be. If you file Form 6 before grant, the certificate name will change. Yes, sir.
Combination of two ideas can lead to a new idea.
Yeah.
Suppose if two ideas, patented ideas, I have read two patents and then I found a new inventive thing.
Yeah.
Let us take one example. Suppose bio paints are there. Paints are already known. Natural products are already known, but I mixed them and then I made a novel paint which is for environmental friendly. Can I get a patent for that?
If it is, that is what morning I explained on the drugs, polyherbal formulation. So we deal with the herbal formulation, same thing. So A is working as a anti-cardiac, B is also working as a anti-cardiac plant, medicinal plant. So now these independently working, they will mix with that. So there should be a synergistic effect.
I claim as environmental friendly. Suppose if it is
Yeah,
saying that
even individual-
is there an option for environmental friendly
Yes,
added
it is
advantages?
anything we will consider it as an advantage to the society. See, A is also environmental friendly. Was that any adverse to the environment? A. B, you are mixing with the B, A with the B, 50-50, 60-40, 30-70, it is up to you. But was there any technical problem was with individual uses? If that is solved, that is the inventive step. So A paint, B paint, you are mixing and making a C paint. C paint you are claiming now. So it's a novel, I agree. But was that inventive? So that is the question, is that now was there any problem with the A separately using, B separately using? C is having any greater advantage than the A and B individuals? So if that is simply admixture, I can use A separately, B separately, I can as well as A and B mixture, same net result is environmental
My question
friendly.
here is, suppose paints have got chemical, synthetic chemical, they have VOC problem, volatile oil, or some other, it is causing harm to the painters. I've changed those ingredients with the natural ingredients.
Yes.
But natural ingredients are already existing, so as a formulation, we can.
Yes, yes, why not? Paint compositions, they are patentable. If I replaced one of the component from the synthetic to natural one, definitely it is environmental friendly and it is acceptable. Advantage, that is also one of the advantage, because that paint is biodegradable. So definitely it is advantageous.
I'll get back to you after giving opportunity to others.
Sure, sure.
I have some biotechnological related questions.
Yes, yes, please. I think there was one question from her. Yeah, please, ma'am.
So when we get the first examination review, So the claims which we get, are they only limited to Indian territory, or if a similar device or instrument has been made in US, UK, do we get claims of those as well?
Yes, we are is that publication, we are not restricting it to Indian patents or Indian patent, non-patent literature. We will check throughout the globe, is there any publication of such inventions? We say check US patents also, Chinese patents also, Japanese patents also, and European patents also, Australian, every country, because as sir was asking about, they are all linked with the search engines. We have a specialized search engine softwares, including Indian patents, we are searching in that. So there we have given access to them, and in turn they have provided their search engine to us. So there is a mutual understanding with them, like Thomson is there and QPAT is there. So there is, we are paying almost 1 crore rupees per year for this search engines patent office. So there we are searching throughout the globe, whatever the publication till that date, your filing date. For example, you are filing a patent application on 4th May 2023, till 3rd May, whatever the publications are there, patent, non-patent, all the journals, we will search it. So we cite even the US claims also. It's not restricted to Indian claims.
And sir, another question. Sir, this Form 18A, which helps in expedition of the process, at what time of our procedure can we fill it? Because I've filed my application and you said like 6 months is required for us to get...
After publication.
Yes, sir.
Yeah. So you can file at any time. See, immediately you are filing, you will be in advantage. Say, I filed yesterday. Today, if I file 18A, or along with the application also you can file. Or sometimes I want to wait, publication is happening. So Form 9 I filed. Publication will happen within 1 week or 1 month. So after 1 month also you can file it. So that will take little bit more, little less than 8 months, because publication already happened. So 6 months wait, after that it will be granted.
And sir, can I file it after my first examination has come?
Theoretically, it is possible. You can expedite at any stage before grant.
Are there any separate fees for the same? For 18?
No, earlier you have filed Form 18, that is 4,000 you have paid. The difference of 4,000 you have to pay now. So it will expedite.
Okay.
With the 18A, there is a online, you have to file online only.
Yes.
Earlier even you have filed offline also. Now you have to file online mandatorily, and 4,000 fee extra you pay. So it will be expedited at any stage, even after a FER stage also.
Thank you.
But I am not suggesting at this stage, because within 6 or 8 months we have a target that before March 2024 all the applications will be cleared, whatever there in the patent office filed with a Form 18. Yes, please.
Sir, in new chemical entity synthesis, A plus B, C we have synthesized. After that we have synthesized 15 derivatives. Can we block that C so that all can be filed for a patent, series of compounds all together, instead of writing more claims?
No, all the 15 they have a application.
Yeah, they have the biological activity.
Intermediaries are having advantages.
Yes, sir.
As a drugs.
Yes, sir.
Okay, then you can, all 15 you can claim in each application.
No, sir. I want to claim only in one paper. Instead of writing 15 claims, I want to write only one claim altogether.
No, one
Or
claim means, no, it is not advantageous in one claim if all the compounds are having a same structure, only difference at one place. So then you can make a Marcus and give it R, and then wherein R is methyl, ethyl, or
Yes,
like that you
only I'm
can
asking,
give.
sir.
So that can be a possibility. In one claim you can.
Yes, intermediate we
And
can.
dependent claim, you can claim it individual compounds.
Yes.
That is possible. That's what in chemistry we get applications. In one Marcus claim, it will be almost 1 lakh compounds they will claim.
Yes.
So it is possible.
Thank you, sir.
Yeah.
Claims, sir, in a US claim, see whether computationally generated claims are acceptable or can we publish?
Computational generation means how you drafted
like R group enumeration, like it is a AI assisted this.
Yes, yes, we are accepting, but working example, you need to show that not on the software. So you have to practically work. So like if I am preparing synthesizing any chemical, say C compound, by reacting A with the B, I am getting a C compound. See, working example must be 10 grams of A I have taken and 20 grams of B I have taken. I have incubated at 120 degree, and then I got within 3 hours of reaction, I got
Okay,
C.
sir.
So this is practically, but theoretically computational models we accept as a claims, but support should be in the practical form.
Okay, sir, one more my question. In most of the, I am working in the medicinal chemistry in the this one. There is no any supplementary data in most of this patents, like in a spectras and other things. How we sanctity of work, and tomorrow also if I claim, most of the time what happens, sir, you know, in a geographical condition, X person if he does the work, it will come. The same things if Y person and Z area, it won't work.
Okay.
Then how?
It's a predictability. Okay. So the question of that data, because we are not giving any data security for them, I even won't advise that you submit all the data to us. We don't require any test data that this compound works. We don't require it. It is for your satisfaction, you submit it, we accept even in vitro data. Of course, we never ask any chemical compounds with a clinical trial data. It's not required for us.
Anybody not claim?
It's required at the either drug controller or FDA, you have to submit that. So we don't require that data. But if for your satisfaction you want to say that this compound works as a anti-cancer or anti-cardiac, you can, like mice or that data you can submit it, we are accepting that. But that data also we don't have any format. So you just whatever the way you write it, so we accept it. But it's not mandatory to submit the data. Because what is we expect in chemical compounds, how you synthesize and what is its structure. These two things are required in chemical. Whether it works or not, you have to write this compound works as an anti-cancerous. That is, we truly believe it is working as anti-cancerous. If it is not working, it is your loss, not patent office loss.
Sir, one more thing. If today I can claim my one compound, it is having, I can patent in a anti-cancer agent. Okay, tomorrow I come to know it is a very good anti-diabetic. So
Yeah.
can I publish that material already I patented?
Yes, same compound.
Yeah, same compounds.
You can publish it as a journal, but for getting a patent as an anti-diabetic drug, same per se compound I am saying, but anti-diabetic formulation you can claim it. Even second patent you can file with the same compound as an anti-diabetic formulation, you can claim it.
But not as activity.
Activity per se we are not granting it, because new use of known substance is not patentable, because the molecule is not new. This NCE is not new. So not new means we will cite your patent earlier one. Oh, this is already known compound. So it will be a new use or new property, you have discovered it. So you can file in that case new formula, that is formulation.
Sir, whether is it not comes under plagiarism if I publish in a publication?
We won't accept plagiarism in patent office. The only journal publications they have.
No, I'm asking out my.
No, it won't come. Even you can just check the US patent. Many times I have seen that almost writings are ditto only at one place. In methyl place it is benzene. And if you see whole specification, it will be 99% same draft. Then also we grant that, because the chemical compound is different. This benzene derivative is not covered in that patent application.
Okay. So my clarification is what I understood. If today I publish one structure, tomorrow, today I have published structure, same structure I can publish in a different activity.
Yes, you can. Very much, sir. Okay. Even same patent applications for a anti-cancer also you can publish it. So there is no restriction. Today you file, tomorrow onwards you can communicate to any journal, you can publish the same invention in that journal. If vice versa means you may have a risk of losing that novelty. If the publication happens before this patent filing, so some controllers will be very rigid. Knowingly you have published, why you have not filed patent like that? We generally give 12 months concession for our inventors, especially academic inventors, but sometimes some controllers will be rigid. There is no guarantee that.
For the benefit of others also, I'm just asking relevant question to that.
Yes.
There is a concept called bioisosterism. Any compound, if it is there already, it is patented. And because it's a geometrical thing, people can change the electronic configuration. I use the artificial intelligence method and I come out with a new compound which may have the same activity. Can it be patented as a molecule?
Yeah. So what we see, is it a new chemical?
It will be a new chemical. But I use the just like we have a mimicking thing.
Yes,
Suppose
mimicking.
If I see
Yeah, I got.
But I changed the entire compound instead of some compound. I've changed, but it will be electronically configured same so that it will act as a drug.
Definitely. So it is patentable, new chemical entity, and it is having a inventive step, and it is patentable. So there is no problem for that. See, how you got that compound or how you did research, it's not our concern actually. So the concern is ours, whether it can be replicated by reading that specification. How you have written that specification, by any public reading, that should be replicated, that compound. So preparation, whatever you have written, A step you do this, B step you do this, C step you do, you will get this compound. So that compound they should synthesize in any way, whatever you are synthesized, they should get it. That is what we look into that. That's what we say best mode of carrying out the invention.
I have few questions on biotechnology related.
Yeah, please.
We have isolated a few strains,
Okay.
be it fungal strains or actinomycetes. Suppose we know the streptomycin is produced by Xn and it is in market, we know. I have found out a new strain which is also secreting streptomycin. Because streptomycin has got commercial importance, can I patent my, in what way I can have the IPR advantage out of my research?
So it's a, see, isolation procedure, if it is not new and inventive, you can, this new strain isolation, you can patent that procedure, not the strain per se, because it's a discovery. And the important part for commercial aspect is that production of streptomycin from this. That process you can very much patent it, because this is a new strain which is producing the streptomycin, and you can claim that this strain production of an streptomycin by this strain. That will be a novel process. So you can claim that strain procedure. It is very much possible that you can claim that new strain, and you might have done already all the techniques, biochemical characterization to know that what is the species and genus, and you might have deposited means all the deposition numbers you can give it. So it will be advantageous that, so you will, before patent filing, you need to deposit. So that is also there.
Okay.
Yeah, if it is not available to the public, that strain, it is with you only. It's a deposition is mandatory before filing patent.
I have a little bit twisted question, same thing.
Yes.
Now that we have carried out research for something else, and we have found some of the strains which have similar industrial applications are there. If I explore the industrial application for already strain, isolated strains, can I look into any patenting aspects in that direction?
So
Like say, suppose I
already
have-
known for this same process,
Not for
production.
known process. We have isolated some strain. Let's say aspergillus is there. In that aspergillus, some specific strain
Okay.
which is by the phylogeny, it may be close to already commercial strain.
Okay.
It is not the same strain, but
Yes,
it is
yes.
showing 99% that
Similarity with the existing strain. Yeah.
existing, but there is a difference in that.
Yes.
In based on the DNA. Can I explore that?
Very much. You can. So you can give the strain number. So you can, this is a new strain, which may be 99% similar to the existing strains, but it has its dissimilar characteristics also. It can be inventive. So aspect is that important what we see. See, when in microorganisms, we generally put the genus or species, whatever, and what is the functional aspects of that. So if you are characterizing at the level of the gene, we will go for that sequence search. Otherwise, we will go the keyword search only.
Are markers patentable?
So we question you how this strain is better than the existing strains. And for that, you need to, I said that advantages you have to show. If the advantage is there, definitely it is inventive and it will be grantable. Process.
Are chemotaxonomic
Markers and all, see, it will be common, 16SR, NA, all these things. I don't think marking or identifying a strain.
Chemical compound. If we saw that particular group of strains by a particular isolated method, they are giving similar peaks at one particular compound. So, I mean, there is something common. So, we can use this particular method as identification of those particular species.
You can, sir. There is no issue. So, you can identification method, but if it is novel and an inventive identification method also, you can claim it, but it is not industrially applicable generally. So, microorganisms, the most important part is the production process. Then producing all chemicals, protein producing, all these things, antibiotic production. So these are generally will be treated that these production methods are advantageous. If strain is not available, you can go for the production processes. Yes.
Sir, once in patent office first publication is done, can we publish same work in other journal?
Before publication also you can publish it, ma'am. Today you file on 4th May. So tomorrow onwards you have a right to publish any high impact factor or whatever the impact factor journal, you can publish it. There is no restriction.
Okay, then we don't have to wait up to grant and all.
But only question is that till the publication, till the filing date, see today you file, till yesterday there should not be publication on this. So that is, if it is there, it will lose the novelty. So from after 4th onwards, you can publish any day, it will not lose the novelty. So even provisional also you can file and publish it. That's also no harm.
Okay, thank you, sir.
Yes? Yeah, you can conference papers or international, national, wherever you want present, you can present it. Even before also, some generally conference proceedings are all not published. So there is no harm in that conference proceedings or poster presentations or that lectures presentation. So if it is published, then only we will get. So otherwise we won't get it. Any questions?
Sir, would like to ask any questions from online participants also.
Yeah, please, sir.
The online participants, if you have any questions, the floor is open for you.
Hello.
Yeah.
Yes. Am I audible, sir?
Yes.
Sir, my question is just you told that after patent publication we can publish the research article also. Sir, we have developed the formulation and we published the analytical paper. And for showing the applicability of this analytical paper, we have added some data of my formulation. So can we publish the patent for separate patent for formulation, sir?
Yeah. So first question, so after publication of a patent, you can publish, you said, I said you can also before patent publication also you can publish it. There is no harm in that. But it should not be before date of filing of a patent. Publication should not be before date of a patent filing. So filing date is important to determine the novelty of a invention. So publication you can do very next day after filing itself. Don't wait up to publication of patent also.
Okay, sir.
A second question, so the combination patents.
Yes, sir.
So whether you can take a combinations in a separate application or not, it is if in combination.
No, not like that, sir. We have developed the formulations.
Okay.
We want to patent that formulation.
Yes, sir.
But before that, I have published the analytical paper.
Okay.
Method development paper, and in that paper we have shown that this method is applicable for this formulation. For that reason, I have added some data of this formulation.
Okay.
So can we patent the formulation, sir?
So generally within 1 year of that publication, analytical paper, you have every right to file because same authors are inventors here also.
Yes,
So
sir.
if that is the case, they can, you 1 year concession you will get, so you can file it. Even after 1 year it is happened, if the same formulation is disclosed in that analytical paper, what you are referring,
Yes, sir.
so that it exact formulation components are given that, sir?
Sir, only one component I changed, but I have not given all the details, sir. Only I have mentioned 10 lines only.
Then there is no issue, sir.
Okay, sir. Okay.
Then exact formulation should not be there.
Okay, sir. Either quantity and other things will change somewhat.
Yeah, in formulation, we even 1% change of a one ingredient will treat them as a new formulation.
Actually, sir, in analytical paper, we are not going to disclose all this quantity and other things.
Yes.
We just give the overview about this formulation, how we prepared in short. And in case of formulation, we give all the details.
Yeah, there is no problem, sir. You can go ahead for filing formulation patent.
Thank you, sir. Thank you.
Yeah, welcome.
Any other question from online participants? So we have come to an end. Yes, ma'am.
Yes.
I have a question
Yeah, please.
regarding dosage form for animal treatment.
Yeah.
Can it be patentable, and what are the prerequisites for application of a patent?
Yeah. So dosage based on the body weight of an animal, so we may not give a patent for the product because it is the formulation we will consider that is also includes the dosage. See, formulation having this A plus B or C is having this much, then you can patent it. Dosage like doctor prescriptions like 50 kg weight, so it has to be 10 mg or 500 mg like that. So you may not get a patent for the fixed dosage compositions. So generally, but this dosage broadly as a composition or formulation, you can claim it. So that is a product for us.
Fine, sir.
Yeah.
Thank you. Thank you so much.
Yes, please. Any others online?
Sir, my
Yeah.
question is that after I filed for the patent or publication of the patent, and I've realized that it needs to be changed to copyright. So is there a procedure that we can change it from?
You need not worry about leave it the patent. You can go for the copyright also. So you can file that. See, there is a, this is not patentable like that, because if it is a just copyrightable subject matter, we won't give a patent. So if it is copyrightable, then you can just file a copyright in that, because if it is patent is published in your name, by default it is copyrighted in your name only. So you can just want a registration on that, you can have it. Yeah.
So one more question from my side
Yes.
regarding design application.
Yes, ma'am, please.
We have designed, like for example, we have designed a transdermal patch by using some technology. Can it be? Can we apply for a design application for that?
If it is a technology, you can go for patenting it, that patch. We require a novelty. See, whether it is a design or patent, it should be a new one. In patent, it is technology, technically advanced patch you have developed, you have to file a patent for that. So it's only aesthetic look, it is attractive to the eyes of a patient or person. So it is a design, aesthetic look. Is it a technology or is it a only aesthetic look?
It is a technology. It is a technology.
You have to file patent for that patch.
Fine, sir. Thank you so much, sir.
Thank you. Yes.
So I hope there are no questions more.
Yes.
So I thank Dr. Sharan Gowda Patil sir, who has taken his time to come here and give us more than a workshop. It was like interaction where we have intellectual property rights and management for startups. Thank you, sir. Thank you for being here and giving a wonderful lecture from the behalf of the organizing committee of IPR and IIC. I thank each and everyone who have been here patiently listening, all the faculties from the disciplines and postgraduates, PhD scholars. Thank you. Thank you very much.
Yeah. So once again, I thank all who have joined online or all who are gathered here in the hall, and also the management, Vice Chancellor, so all the organizers of the program. So thank you all. Hope in future the all will try to get their creations patented or some other IPRs. So thank you all.
Thanks. The tea has been arranged outside, so please, before you have a tea.